May it please the court?
Yes, sir.
Your Honor, we are on indictment number 2020 GS 45-140. State versus Everett Jermaine Fulton. He is charged with criminal section 33 and is pleading guilty today for the lesser included offense of assault and battery in the third degree. The state's recommendation in this case, the time served sentence, a permanent restraining order to be put in place. Your Honor, present in the courtroom today. This case was on the trial docket for this term. It is one of the cases that are on the list of cases from the Supreme Court that is over 365 days old. During the trial preparation last said that this is what results she wanted in this case, and she wishes to present a victim impact statement to the court at the appropriate time.
Step forward, please. Place your left hand on the Bible. Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth and the truth and nothing but the truth?
Mr. Barr, is that right, sir?
That's correct.
How much time was served?
Your Honor, he served 4 months.
Okay. 20 days.
It's more than 30 days in that statute carries. I believe it comes out to.
Well, I can circle days or months.
The safest bet would be, it looks like it's 3 months and 1 day is what I have by my run now.
Mr. Fulton said it was long. He said it was 3 months after.
Okay. I trust Mr. Fulton.
Mr. Fulton, sir, how do you plead on the charge of assault and battery third degree?
Good.
Mr. Fulton, are you satisfied with your lawyer, Mr. Barr?
I am.
Has Mr. Barr answered all of your questions to your satisfaction? Have you any complaints about Mr. Barr? Have you told Mr. Barr everything you know about this case?
I have.
Do you understand?
I do.
You have 10 days to appeal the sentence of this court and the plea. Do you understand that? You could face up to
30 days.
30 days on this charge, and had it not been lowered, what could the possible sentence have been?
On the original charge, it could have been up to 10 years.
Do you understand those things, sir?
Yes, sir.
The recommendation today is time served. I don't have to follow that. Do you understand that?
I do.
This charge, really like all charges, could lead to the enhancement of future charges of any type. You have a record. It'd add to your record if you've got one. Do you understand that?
I do.
Mr. Anderson?
Yes, Your Honor. On 10/19/2019, Officer Miller with the Williamsburg County Sheriff's Department received a call to report to Williamsburg Regional Hospital in reference to a possible sexual assault. He met there with the victim in this case. Investigations to get them in on the case. Pamela Wren was assigned the case. They reached out, spoke to her about the case. Of the new drugs, and she's confused how she got in that situation. Pamela Wren reached out to Clarendon County Sheriff's Office to figure out what happened and how she ended up in jail that evening. She spoke to officers with both Manning PD and the Sheriff's Office. She was in a vehicle that was involved in a high-speed chase in Clarendon County. That a male occupant who was driving the vehicle wrecked the car during the chase and ran and left her in the car. There was a substance, I believe it was marijuana, in the car near where she was. She was grossly intoxicated under the influence of either drugs or alcohol in video. And they booked her on those drugs because they were near her in the car. Law enforcement reached out to her friends and they said that Everett Fulton was at the club that night, that he was fixated on her, and when they all go to the club together, they all leave together. And so that night, when it was time to leave the club, they began looking for Mr. And her friends say that they were directed by others that a vehicle with Mr. Fulton is behind the club. When they approached the vehicle to try to see if she's okay, the vehicle accelerated away at a high rate of speed and left the parking lot. It is a vehicle that is associated with a relative of Mr. Fulton. Law enforcement then reached out to Mr. Fulton. he gave an interview with law enforcement after being Mirandized and said that he had sexual relations with the vehicle that night in the parking lot of nightlife, but in his opinion, it was entirely a consensual event. The criminal completed and no evidentiary information can be derived from the test. Those are the basic facts of the case, Your Honor. This defendant has a possession of marijuana and a bunch of driving offenses on his rap sheet, and I have the victim, and I've spoken extensively multiple times. In fact, in preparation to bring this case to trial this week, this decision to plead this case is hers. She doesn't wish to address the court, but she has written a victim impact statement that I have shown the defense, and I'd ask to pass it up at the appropriate time.
Okay. Mr. Fulton, I overlooked it, but I'm reminded by reading her letter that they also are requesting a lifetime permanent restraining order regarding you having any contact with the victim or her family for any reason whatsoever. You understand that?
I understand.
Either lawyer, correct me if I'm wrong, you won't be able to possess any firearms or ammunition while that's in effect. Do you understand?
I understand.
Do you have that order with you?
I know you are. I compare it. That is up to the judge. If you're ordering it, that is how it's done. Okay, and I will put that provision in. Yes, sir.
Mr. Fulton, you've heard the recitation of what's happened, but now, Mr. Anderson, it's my understanding that the victim agrees for this charge to be assault and battery third degree and not CSC third degree or worse.
Yes, Your Honor, you can ask her. I met with her. This was the case we were going to try this week. During trial preparations, it was a long discussion we had, and this was the decision she made after reviewing the evidence. She said she doesn't want to address the court. You can make a reason.
She's here with us.
She's right.
How you, ma'am? How you today? All right, let me know for the record that Miss quite responsive in her questioning, very engaged, no hesitation, no equivocation. And I find she made her decision to support this guilty plea freely, knowingly, and voluntarily. Now, Mr. Fulton, you've heard what she has described that happened through the solicitor's office. Is what I heard substantially correct?
Yes.
Do you still wish to plead guilty to assault and battery third degree?
Yes.
Mr. Barr, do you have any concerns about his plea?
No concerns about this plea, Your Honor.
I find he's well represented by Mr. Barr. We've worked together many times now. He's offered his plea freely, knowingly, and voluntarily with advice of good counsel, and I find it to be factually based, and I will accept it. The recommendation, Mr. Barr, as you well know, is time served. Any objection to that?
No objection, Your Honor.
The court will accept the recommendations with great emphasis placed on the consent of the victim who wants the court to do this. I can understand her reticence and perhaps going through a trial here. I will honor her request. The sentence of the court will be 3 months.
And Your Honor, permanent restraining order?
Yes, sir, permanent restraining order.
I'll draft it and send it to the bar.
Okay.
Praise God. And I can say that T.Y. sometimes when he calls me, even though he's always happy and jolly, but then every now and then he calls his big sister and he says, "Good girl, it don't sound too good. Y'all know I'm weird. I do things like T.Y. We're always doing weird things, amen. We don't fit in, do we, T.Y.? Amen. Amen. And we don't wait for things to happen. We make things happen. Amen. Praise God. When you are connected to Faith Believers Church, you make things happen. You don't wait for things to happen. You get up early in the morning and you make things happen.